I'm Aizada, CEO and founder of Alma, attorney by education and experience. I graduated from Harvard Law School. Originally, I am an immigrant from Kyrgyzstan, which is a country in Central Asia. I've practiced law for maybe 7, 8 years, then pivoted out of law, was a consultant, and then started Alma 3 years ago. Alma is a tech-enabled immigration law firm. I think one sentence that summarizes us very well, it's a immigration law firm that works like a tech company. We are customer obsessed, we care for the outcomes, and we really care for immigrants' experience because all the founders of Alma are immigrants, and this is really the DNA of our company. And Jihan is our head of immigration strategy and client solutions. Do you want to go on camera and introduce yourself quickly?
Yes. Hello, everybody. It's really great to, well, I can't see your faces, but I'm really glad that you all could join. My name's Jahan. I am an immigration attorney. I've been practicing for over a decade at some of the largest immigration law firms, and I sit in Boston. One of my favorite things to do is to sit in on these webinars with Aizada and to hear from all of you. And what we like to do at Alma is to solve problems. So if you have a problem with your immigration program, case-specific stuff, do reach out to us separately. But if it's a question that's helpful, you think for the broader group, that's the perfect thing to drop in the chat here. So really looking forward to speaking with you all.
Thank you so much, Jahan. This is great, and I'll already start presenting. H-1B lottery just has concluded. What now? The purpose of this webinar is to inform those who handle immigration in-house. So you are either global mobility professional or someone within the company who handles it, and because there is no one else is, and you just deal with it. And you're trying to understand, okay, there are people who did not win the H-1B lottery, and what are the strategies? Today, we will go over the following things. First, I just want to share some of the key takeaways we had following the H-1B lottery results. What does it mean? What was different? The second is selected employees. What does it mean for them from the travel perspective, from the timing perspective, and risk factors? The other thing is contingency planning and alternate visa pathways for non-selected employees. And then we'll reserve some time for Q&A. I want to be super mindful of all of your times, so I'll watch the time and make sure that I hopefully speak for around 20 minutes. In parallel, you can ask any questions that you're coming up as I speak. Jihan will address those, and I'll also reserve 10 more minutes towards the end of the webinar to address your questions live. With that, H-1B lottery, what we know. So this was the first time ever where wage-based selection was implemented from level 1 to level 4. Higher wages correlated with higher selection rates. And overall, this and also the 100K fee led to the fact that there were less registration entries this year. And what's become super important is the accurate wage level selection. A lot of companies, I think, just try to optimize for the higher selection rates, but we can also talk about it, what it means in reality, and what's the potential pushback you might get from USCIS. Our selection rates by wage level across all the clients we had is shown on the right. You can see it was the highest for level 4, 74%, which is unprecedented. 70% for level 3 is also amazing. It was 58% for level 2. I think we overall got very, very lucky. This is not what we heard from the market. And level 1 has 31% selection rate. This is how it looks like. We know it from all of our client base. And what not selected means. I'm sure everyone in your teams were very discouraged if they were not selected. If they were not selected, it means that there's literally no work authorization coming from them in October. And what immediate plan you need to do is you must assess all the employees that did not win H-1B lotteries for other visas and have a strategy in place, what you're going to do for them, especially for those that will be running out of work authorization very soon. Who needs a plan? Because there is a two category of people. First one is lower risk. Those who have some sort of other work authorized visa and they're eligible for continued extensions like TNs, E3s, O1s, H1B1s. Well, who is at risk? At risk are those international students on OPT and STEM OPT expiring within 1 year. L1 visa holders that will max out in the next 1-2 years. What you need to remember is that USCIS combines L1 and H-1B max out calculations. If you do not have an approved I-140, which is a green card, you will max out on your H-1B and L1, which is essentially 6 years. And they combine it for the purpose of calculating the max out calculations. And then the other one is humanitarian-based holders. Those people who are on DACA, TPS, U4U, and similar statuses. Why? Because we've seen a trend with this current administration where they've been terminating this humanitarian-based holder statuses. It's a lot of unpredictability. That's why you should care for them a lot, and they pose a significant risk. So one important thing to note, unlike H-1B holders, L1 holders are not eligible for extensions under ACA 21 based on perm or approved I-140. So you need to plan ahead for them. And now I will jump into these categories more specifically. Please let me know if I'm moving too fast and I can readjust my speed. First, we'll look at international students. Those are in F1 OPT, STEM OPT. OPT, STEM OPT. This is what needs to happen is that you can extend work authorization if H-1B is timely filed, requesting change of status while F1 is valid. The other thing is that for certain degrees that are STEM, there is a 24 months extension. This requires e-verify employer and complete a training plan, but this is something that within your control and you can do. What needs to happen in terms of action item, you need to confirm the e-verify enrollment and prioritize employees whose OPT and STEM OPT statuses expire within a year. What is CPT? CPT is a status that essentially people could get if they enroll as students with universities that can give you day one, basically work authorization. And they can get this CPT if OPT STEM or regular OPT is unavailable. What you need to remember, it must be clearly tied to the curriculum. Not all programs qualify. You can review the programs and see what are their offerings. And you need to understand that CPT has an increased scrutiny from USCIS, especially those day one CPT programs where you enroll and you get a work authorization right away. They look at whether it is actually they have an intent to upskill themselves, right? Because that's the purpose of studying. You need to enroll into the program because you want to upskill, but also you have a job and you are able to do two things in parallel. But this is really may create a downstream risk down the line because when you are changing the status or doing an extension or filing for a green card, this is when USCIS will scrutinize the intent. Did you really intend to study and upskill yourself, or you just use it as a cover up for a gap that you had in your work authorization? So you must clearly vet the institution and also ensure that program overall ties to your company goals and it is relevant for the job of your employee. And of course, the bottom line is that the strongest is OPT and STEM OPT if your employees have it. The other option is Cap-exempt programs and filing concurrent H-1B. How does it work? There's certain organizations in the US which are usually nonprofit companies that they don't have to participate in a lottery. So what essentially they can do for their employees, because they're nonprofit research organization, they file for their employees, they never subject to H-1B. And this program of filing a concurrent H-1B works in two steps. First, your employee essentially would be an employee of the research Cap-exempt organization as well. They would file for an H-1B for your employee, which is also their employee. Your employee would dedicate some amount of time to that organization, and then using that Cap-exempt H-1B, you file a concurrent H-1B, which is a piggyback option on top of the Cap-exempt H-1B. You file a concurrent piggyback H-1B on top of it so that your employee essentially is double employed, if you want to look at it that way. They work for the Cap-exempt research organization and they also work for you. In reality, how it works is also they need to be employed for this Cap-exempt research organization for the same essentially skill and job responsibilities they do at your company. A simple example is someone who's a consultant, someone who does strategy and ops function. They could be a strategy and ops employee for the Cap-exempt organization, and they perform the same function at the company. So you can file a concurrent H-1B. So the challenge is that at all times, the person, your employee needs to maintain employment with a Cap-exempt entity because that's what gets them the concurrent H-1B. And the Cap-exempt organization must be supportive of the multi-employer arrangement. This is something that law firms can help you with. If you work with a law firm and they have partnerships, this is what you can get done. What Cap research organization is really looking for? What they're looking for, they have a gap, but clearly they cannot get the type of an employee you have. For example, someone who leads growth or strategy and ops or product marketing or an engineer who you pay a lot of salary. Nonprofit research organization most likely cannot attract that type of a caliber of talent. So they discuss with you what would be the split, how much time they dedicate to them, how much time they dedicate to you. And then it's a scoped project, and then they deliver some value to them. So it's real work. It's not some sort of fake work. It's real work where you have to essentially split your employee between the research organization and your company. But of course, your company plays a bigger role, and then they spend less time with the research organization. What needs to happen is that the CAP research organization must qualify as Cap-exempt company. So you can do it through your immigration law firm. And then the other one is that both position must be the specialty occupation and prevailing wage requirements. The other visa that you can look at is O1 extraordinary ability visa. A lot of companies, I'd say, overlook extraordinary ability visas because they just think by design they're hard and they think their employees do not qualify. To be honest, it costs you nothing to get this assessment for them, whether they qualify or do not qualify for extraordinary ability visa, because it's more about the employee profile. If they qualify, great. This is still a company-sponsored visa. It is still tied to your company. It's given for 3 years, and then it's extended in unlimited 1-year extensions. There is no annual cap, and you can pursue a green card concurrently. There is no formal salary or degree requirement. They can work for one or multiple employers. Premium processing is available. But the challenge is there is a high evidentiary standard, and the role must relate to an area of expertise. So, for example, you've hired an engineer, and this engineer is one-of-a-kind engineer that specializes on, for example, speech to text, right? Like they really can just take natural language conversations and put it in text in the best way. They might not have written letters about it. Maybe they have built some GitHub repo, some sort of like GitHub open source project that got adopted by thousands and thousands of engineers. And you've hired them for that because they have the skill and they have the expertise in certain area. So then we really need to work with them to see if they qualify for one of these 8 criteria to qualify for the O1 visa. The downside, of course, is that their dependent cannot work, but this is one of the great alternatives for companies. We work with a lot of companies and they've been surprised that we were able to get O1 visa for their employees when they didn't even know such visa existed. And we truly were able to save some of their great employees from leaving the country. What are the visa requirements? There are 2 things. One thing is that they have won some international award, or they must qualify for at least 3 criteria out of this 8. Usually the first one is not really applicable. You must win some major, like, I don't know, Nobel Prize, Pulitzer Prize, some sort of major award. It's not the case for majority of the employees. So you move on to seeing whether they qualify 3 criteria out of 8. Usually, what happens with critical employees? One of 8 criteria is critical role for distinguished organization. If it's truly a critical employee, you're like, we gotta save them. Like, we really cannot leave that. We really cannot afford them to leave. You're really in a pickle about some critical employee. If their role is critical, usually that's the case. And then we have to also, the second one is high salary or remuneration. If you are willing to pay them wage 4, and if their salary already fit for wage 4 in California, in like Santa Clara, San Francisco, and then maybe even more, they might already qualify for 2 criteria, as you can see. And then we will talk to them and figure out maybe what are the other things. And if it was an engineer who really like built this GitHub repo, which got adopted by so many peers, then this is an original contribution of major significance. This is up to your immigration vendor to qualify them and to tell you what really works in this case. Then the other visa is an L1 international assignment strategy. What you need to think is that, like, do you have a foreign entity, and whether international assignment strategy works, which essentially means is that you open a company abroad and then you move your employees with an intention of moving them back. What you need to know about this is that there is no lottery or annual cap, supports executives, managers, and employees with specialized knowledge. That you must remember. So if these are like head of teams and they manage people, or if these are employees with specialized knowledge, L1 will work for them. What needs to happen? They need to be employed abroad by you for continuous 1 year. And you need to establish qualifying relationship between foreign and US entity. Ideal is that if the US is the parent and foreign entity is the subsidiary. There's a specific problem with if you are doing it through EOR, and if you're doing through one of those companies like Rippling, or to hire them abroad, this will be way harder to prove this qualifying relationship between the foreign and US entity. And then when they move abroad, the role still must qualify as managerial, executive, or specialized knowledge. And you shouldn't be thinking like, hey, we're just going to set up some shell entity. We're just going to set. No, that entity must be operating entity. You need to pay taxes. You need to run payroll. You need to have some, business, that real business that will be operating abroad. So it is not a shell entity that you can set up. It will be scrutinized. For managers and executives, what usually is the requirement, or like the baseline? 7 years of maximum period of stay within the company. Role must be primary managerial or executive. Direct pathway to EB1C green card, which is great. For specialized knowledge, 5-year maximum period of stay with the company. Employee must have special knowledge of the company's products, services, interests, or advanced knowledge of internal processes and procedures. This is something you can easily prove for key and critical employees. Then TN for Canada and Mexico. This is a visa that basically is viable because of the government agreement with Canada and Mexico, and being them part of the trade union. Key features. This is fast processing. There's no capital lottery, and may be extended or renewed indefinitely. But the challenges. There must be a strict alignment with listed professions. It's not suitable, unfortunately, for sales, for marketing, or manager roles. And the challenge is that it's non-dual intent. There's you can file for a green card for them, but if you file for them, they will face severe travel and renewal restrictions until the green card process, you actually get the green card on work authorization travel documents. What is happening right now? What are the trends with TN? We are seeing increased scrutiny at the borders. And what they're looking for is that the degree and credential requirements must meet the minimum bar, and then the role must match a TN eligible profession. This has been scrutinized a lot lately. So one of the strategies is that it can be approved through USCIS if the person is inside, and you can do a change of status, or they can cross the border. So companies have been, it's like getting approved through USCIS is more expensive, but also if the USCIS approves it, maybe at the border, they're less scrutinized potentially. The other visa that you can do for them, if they're nationals of certain countries, is that there's an option of E3 and H1B1 visa. Usually, you just have to figure out immediately is that if you have citizens of Australia, Chile, and Singapore that did not win the lottery. Because the key features of this is there's no lottery requirement. There's similar framework to H-1B, specialty occupation standard, and it's renewable in increments. Some are in 2-year increments, some are in 1-year increments. The challenges is that, of course, it's limited to nationals of certain countries, must meet specialty occupation, less flexibility long-term with immigrant intent, especially with H-1B. And it really requires a very careful role definition and documentation. Requirements: specialty occupation role, degree in related field, employer, of course, sponsorship required. And of course, there is a LCA certification by the Department of Labor. And then there's another option, which is L1 intern and trainee, which is essentially designed. The key feature is that it was designed for, and it was aimed at training and cultural exchange, not per se employment. So it allows US companies to host foreign nationals through approved programs. And it's very useful for like early career talent or skill building. But it's not that you can really hire experienced people on this visa. So there are two types, J1 intern and J1 trainee. J1 intern is currently enrolled abroad or graduated within the past 12 months. That must be the requirement. So it works well for those who are on F1 OPT, but they're not eligible for STEM because they did not graduate from STEM professions. And then training must be directly related to field of study. And the program must involve only skilled work, not unskilled and routine work. You cannot hire them to do some admin work. The challenges is that requires a US State Department a designated sponsor. It cannot be that you just decide to do it and you can sponsor. And there is a formal training, but usually your immigration vendor can help you with all of it. But it's not intended really for long-term retention because you really need to think about it. It's like, hey, it's for a limited amount of time. What we do next? Some programs might trigger a two-year home residence rule when they have to go back and stay in their home country for 2 years. And then there's J1 trainee, where there's a degree and there's at least 1 year of related work experience abroad or 5 years of related work experience abroad if they don't have the degree. And training must enhance the skills and not duplicate to prior experience. So this is J1 intern trainee. Again, you work with your immigration vendor and you need to ask them if they work with companies that already have this relationship with the US State Department. And then the other option, which is also overseen in a lot of cases, is that you also need to see if they have a spouse married legally, and if they hold certain types of visas, you can get a derivative visa for your employees. Also overlooked a lot of times, surprisingly. So qualifying categories, L2 spouse, if their spouse has L1 visa, if they're on E1, E2, or E3 visas, and you can get a derivative visa. And if their spouses are on H1, and then you can get them in H4. But there's a caveat, they need to have an approved I-140, which is a green card. So essentially they've applied for a green card. Green card consists of 2 stages, approved I-140 and the adjustment of status. So they have the approved I-140. This usually applies for nationals of China and India, which have a really, really long wait time. But the most important is that you get the I-140 approved. And if they have a spouse who's an H-1B with approved I-140, then you get an H-1 for them. And then J2 spouses, if their spouse has J1 visa, then they can apply for it. Of course, there are all the caveats about what are the limitations, and your immigration law firm can help you work through them. But this is just for your information so that you know it exists and you can do it. Who is not eligible for work authorization is that if they're on F1 visa, if they're on B1 visas, and if there are other categories, majority of them. There's also B1 temporary business visitor visa, which is like if your employee couldn't stay in the US and then they move abroad, and if you want to bring them temporarily for some time, for short amounts of time, what is really permissible? Because a lot of companies get it wrong. Truly, this is so critical. You cannot have them work on B1 temporary business visitor visa. What are the permissible activities? Engaging in commercial transactions that do not involve gainful employment in the US, negotiating contracts, consulting with business associates, participating in conventions, conferences, or seminars, and undertaking independent research. This is what is permissible. Key restrictions: no productive employment. It's like you cannot have your engineer go abroad and come down on B1 visa and then they continue shipping code. This is not permissible. Cannot do work that benefits US entity in a hands-on or operational way. Like they can really not do it. They can come in for like business meetings if you're having like retreats and associated business meetings where you're strategizing for the year, whatnot, but you cannot bring them for like something that is really hands-on and an operational way. They cannot receive a salary from the US source. They have to receive from the entity abroad. And there are certain limited exceptions. Immigration lawyer can get you through them. And it cannot be used to bridge, an ongoing US work. So it's not like, hey, like, let us move you to B1 visa and let us sort out another visa and change your status. USCIS will highly scrutinize this. And what you must remember, it's all about the intent. If you're entering the US all the time on temporary business visitor visa, they'll scrutinize it. And this can lead to future denial of entry or future visa issues. And it's a compliance risk for you if it really resembles true work versus just like they're just coming for short amount of time and they're just doing these permissible activities. And they must maintain a residence abroad. They cannot be just like, they must have an intent to depart. And there are also some other options, which is like when you just do remote work and international assignments. International assignments is like with L1 or hiring employees through employment of record, but to stay compliant. But you just must understand what are the implications if you're doing an EOR, whether you can bring them on L1. The challenges is, of course, is like tax and employment law implications in the destination country, and also all the operational complexity and burden of setting up a new entity. And then it's like what we can help you with. So what we do as a law firm is that we do free assessment for everyone who did not win a visa, win an H-1B lottery. We can help you assess them for free, and we can help you strategize. We can do a strategy session with you and just being like, okay, does it work? Does it what now? What are the trade-offs? So that you can go to your management with a very well thought plan where you're like, hey, like, this is my plan. This is the work that I have done. These are the recommendations. And then what we really do is that we are tech driven, right? So for every single visa that you do, everything is visible on our platform so that it really improves the employee experience. All the emails that they're sending you about like what's happening to my case, the law firm is not responding, all of it will just stop because everyone can see what's happening at all times. You have full control of your immigration vendor, and you really should, because otherwise, what are you even paying for? And then, of course, is like what we do is that we take compliance of your plate fully. We guarantee data integrity so that you can trust all the data because it's all live. You can verify it quickly with all the sources, and we truly ensure that compliance is there for you. We on most of the visas, we guarantee 2 weeks turnaround time of documents. We have 98% approval rate across different visas, including O1. And we have the 86 NPS score. For those who don't know what NPS stands for, it's Net Promoter Score. 86 is a dream come true NPS score, and that's what we strive to maintain at all times. If you go on tryalma.com, get started, and fill out the form, I'll keep it here so that you can all see it. We do a free consultation, and we really do a strategy for you, for all of your employees that did not win an H-1B lottery, so that you can have a very clear picture of what's going on. You can also email satika@tryalma.ai, and you can also just, point at this QR code. You can get started with us. Thank you so much, everyone. Have a great day, and I hope to see you again.